Good afternoon. On behalf of K&S Partners, I would like to welcome you all to this webinar, A Pinch of Salt and Law for Innovative Pharma, Patents, Innovation and Pharmaceutical Industry. And thank you for sparing your valuable time to be part of this event. Today, we have distinguished panel with us, Honorable Mr. Justice Manmohan Singh, Chairman, Intellectual Property Appellate Board, who will deliver special address. Dr. Dinesh Patil, Deputy Controller of Patents and Design and Head of Office, who is guest of honor for today's session, and senior representatives of innovator pharmaceutical industry. I will read out some house rules for this session. Attendees may please place all your questions in the Q&A box visible on your respective dashboards. Please mention your name and company name along with your question. Please also mention name of the speaker to whom the question is addressed. We will have a live Q&A round towards the end p.m. and you may use the raise hand icon if you are interested to ask your questions live. In the interest of time and more questions, we will prefer questions coming into the Q&A box. Please have a look at your chat box where the webinar help desk will be posting updates regularly. May I now like to request my colleague Namrata Chadha to kindly introduce Honorable Mr. Justice Manmohan Singh and set context of the webinar. Namrata is partner at K&S Partners working in Chem Pharma patent practice of the firm. Over to you, Namrata.
Thank you, Kavita. Good evening, everyone, and I welcome all of you for this session today, and thank you for sparing time. About 15 years back, India amended its patent law to allow for product patents. And with it, India showed its strong need to enter the arena of advancement. As most of you would agree, there has always been some contradiction between the need to share technology and the need to incentivize the inventors. For this reason, most robust patent laws have been tested and challenged continuously. And often such challenges help in shaping the jurisprudence. India is not far behind. From the decision of the Honorable Supreme Court of India in one of the anti-cancer drugs, that is imatinib in 2013, to the very recent decision of the Honorable IPAB in another tinib, that is ceritinib, India pharmaceutical jurisprudence has undergone a sea change. And much of the credit goes to our Indian High Courts and the Honorable IPAB. I would say the Office of Controller General of the Patent Trademark of India and the Indian Patent Office is not far behind. With be it the national IPR policy, the regular amendment of the patent rules, the transparency and the expedited examination, the Government of India has been continuously working in shaping up the ecosystem. Our chief guest for today is someone who has been instrumental in shaping the pharmaceutical patent laws in India. He joined as an additional judge of High Court of Delhi in 2008 after practicing for several years as an IP lawyer. He has delivered numerous landmark judgments and decisions under the Arbitration and Conciliation Act, Patents and Trademark Act, as well as the Copyright Act. Currently serving as the chairman of Intellectual Property Appellate Board, he is one of the most prolific writers of IP decisions. Ask any IP lawyer, it's always a pleasure appearing before your honor because you just don't have to deal with the basics. It does not take much to guess who I am speaking about, and join me in welcoming Honorable Justice Manmohan Singh. Your Lordship, it's our privilege to have you here today, and without much ado, I hand over it to you to share your views on how you administer justice in pharmaceutical patents and the road ahead. Your Honor, over to you.
Thank you so much. Good evening to all. I have about 25 minutes. In 25 minutes, I will give the overall picture so that everybody should understand the issue involved. Today, we are concerned with pharmaceutical cases, pharmaceutical law. As everybody, Ms. Narmada has also stated that after the amendment in two times, that is basically 99 and 2002, you know, large number of application for registration by the pharma industry have been filed before the patent office. Number one. Number two, as earlier I was practicing for 28 years between 2080 to 2008. 28 years I was practicing in the High Court. There were very few cases, very few cases of patent, and particularly in pharmaceutical products. And once these amendments have come, and I have noticed that there was a flood of cases in the High Court of Delhi at New Delhi by the pharma industry, by the pharma industry. No, no doubt that there are many challenges. There were many challenges, and there are many challenges even as of today. And reforms are needed in our level, in the patent office, before the IPAB, or before the Honorable High Court. I can tell you that if we see the record in the patent office, more than 70% applications have been filed by the pharma industry after the amendment. That was the main purpose. And in case the record of the High Court is examined on filing of the patent cases, more than 80% cases are pending, filed by the pharma industry against the pharma industry. There's a litigation. But before coming to the main issues, I must say that Patent Act, first of all, we must understand India do not have any special court, civil court, in order to decide the patent matters or any IPR matters. Number two, Patent Act is a special act. Number three, we must understand that the term of the patent is 20 years from the date of application. And one has to go with so many hurdles. And you are expert, you are professional. Every day you are appearing before the patent office. You people are appearing before the court. You people are appearing before the IPAB. And I can say that it is a now progress is started, but still it will take time. It has been examined in many cases that even at the initial level, the more than 19 years are expired, 19 and a half year expired. Recently, IPAB has given the judgment where the 19 years and 6 months expired at the time of hearing of the appeal. And ultimately, we allowed the appeal, then basically patent is to be granted. And lot of reforms are required. I have already mentioned to you. So if we you will surprise to note that before IPAB, because earlier I was a judge of Delhi High Court dealing with large number of patent matters, although I was dealing with other matters also, arbitration matter. But in IPAB, I can tell you there were about 750 matters, and out of 750 matters, more than 600 matters are pending, filed by the pharma industry. And surprising part is that the matters are pending for the last many years due to many reasons. Sometime chairman was not there, sometime technical member patent was not there. Appeals are pending since 2011, 2012. Now, the point is there are two layers of opposition before the patent office under section 25(1) and 25(2). If that is the situation, then basically reforms are needed. It is a very serious thing. And very recently, I've been discussing with the technical member of patent, that wherever something is to be done, we must do it so that at least the genuine inventor must have some term after the grant of patent. Because many cases, I was very painful as a judge. I am telling you that in many cases, patent expires during the litigation period. Patent expires during the pendency of the appeal under section 117 before the IPAB. And the only remedy left with the damages, and it is very difficult, I am telling you, to prove the damages. Very difficult to prove the damages. As I've already mentioned that the total term is 20 years. There is no protection of the patent unless the patent is granted. No common law remedy is available. No criminal liability under the Patent Act, even somebody has got the patent. And one must understand, patent law is not like trademark law. It is unlike trademark law. If the trademark matter is filed on the first day itself, the court is aware that whether, because it is for the court to decide, 1965 Supreme Court, Pandit Kaviraj matter, 980 and 989, they say it is for the court to decide whether two marks are similar or not. If those are similar, no evidence is required. Then there is a provision of Order 12 Rule 6 that the court can pass the decree at the first instance. Then Order 15 is concerned, if there is no issue about the trademark, court can pass the decree. Even in trademark matters, the defendant says that I have not infringed it, but the court feel that the two trademarks are deceptively similar. The law has gone to that extent that even the court can pass the order straight away, decree the suit. In patent matter, the difference is that if we read section 107 of the Patent Act, it is unlike trademark procedure. In trademark, when the matter goes to the court says prima facie registration is there, the infringement may be there, but in Patent Act, no. 107 says all the grounds are available to the defendant who is contesting the matter. He can put it everything in the written statement, and the court is duty bound to decide each and every contention raised in the written statement. If the revocation is pleaded, then all the grounds available under section 64 has to be considered by the court. So it is not an easy job, because in patent matter, if it is a contested matter, evidence is a must. Evidence has to be there. Next is that all the IPR matters are commercial matters. Nobody can say, because I'm telling you, there were so many discussion with the law minister when Mr. Arun Jaitley was the law minister at many times. So he felt and discussed with many people that we must have some commercial court so that IPR matter should be expedited. Unnecessarily delays are happening in patent matter. Although commercial court now dealing with so many subjects, but initially it was started from IPR matter, particularly patent matter and pharmaceutical cases. They say this ultimately the commercial court came under the Commercial Act. Now basically I feel I feel that if somebody is appointed to deal with the commercial cases, he must have commercial mindset. Then basically one can decide the commercial matter. Otherwise, it is very difficult. Second is, one must understand that the judges are appointed from various backgrounds. some advocate is practicing on criminal side, somebody is practicing on civil side, somebody was practicing in custom law, in income tax cases, and he is appointed as a judge of the court. They are very successful judge, no dispute at all. They can handle the patent matter also. But it depends upon case to case. It depends upon the mindset of the judge. And admittedly, we don't have the special court who can deal with the IPR matter. Now, in patent matter, I feel that it is a very balanced act. When matter comes before the court, many times it has been noticed that why grant ex parte order, because the defense of the other side is not available, because defense is too wide under section 64 and read with section 107. So in most of the cases, court says, all right, give short date notice and let the other side be there. Let us see the defense, because the brand names are different. Why not basically hear the other side? Then we may pass the order if so required. I always mention to the student in Bangalore also and other university also that it is also a matter of fact that at my time, 1980, the plaint of the patent infringement or design is just 6-7 pages, and coupled with few documents up to 50 pages, Now the situation is changed when the pharmaceutical cases are filed before the court. We have been seeing that the plaint is covered 50 pages and documents may be 500, 600, 700 documents. That is also one of the reason that the ex parte injunctions are not being passed. The judge is always in dilemma whether, suppose I pass the order without going to the other side, defense of the other side, or without going through each and every paper, because the judge is loaded with so many work. Judge is having 70 cases, 60 cases in physical court. He is dealing with 20 subjects same day, and 2 or 3 matters are, one is of trademark, one is for copyright, and one is for patent. So I tell the student that they must give a very precise plaint in easy language, and so that court should understand and their culture should be maintained, that the ex parte injunction should also be passed. And second, basically, I always tell the student that before filing the patent suit, one must give the notice to the defendant so that he may give the reply, so that defense come up before the court when the suit is filed for infringement before the civil court. So that judge should go through the reply and judge should also go through the plaint so that he may make up his mind at the time of ex parte stage. Otherwise, suppose the defense is not there, section 64 is there, section 107 is there, the court may not pass the ex parte order. Court simply say, take the notice for 1 week, or take the notice for 2 weeks. So when basically other side will come, suppose the notice is issued, here basically the main war starts. I'm telling you, I've been facing with so many cases, defendants and companies are all, both sides, very big companies. They are not basically one big person and one small. If foreign companies, they are Indian companies also very strong pharma industry. If it is a if it is a genuine invention, or if it is not a genuine invention, but it is very successful, commercially successful in the market, then the other side will file tooth and nail. They will never basically spare. They will raise all the defenses under the sky, whatever defenses are available. And you will surprise that in the written statement, they will raise all the grounds which are available under section 64. So that the judge may impress with the defense, and the moment, because the law is quite settled in India as well as abroad, that if plausible ground is made, if the judge thinks that ultimately suit may be dismissed after trial, then basically injunction may not be granted or even after notice, and the party may be put up for some terms. Either some security should be deposited or some terms may be fixed, that trial may be expedited. So this dilemma is there, and then basically appeal and SLP in the Supreme Court, and then it is a matter of trial. And in the trial, the court will see whether basically case is made out or case is not made out. And one more important thing I want to mention, that the one of the defense is public interest. Public interest, there are so many things. They say, no, foreign drug is so expensive, and Indian pharma industry, they give in very cheap price. Why not basically have the public interest issue? And I admit that everybody has its own perception. Every judge has its own perception. One judge has the perception that it is my country, public interest is involved, why I should pass the injunction order. And other judge thinks other way, because generally granting the injunction, there are three principles. Number one, prima facie case. Number two, balance of convenience. And number three is injury. And now basically in commercial successful patent, the fourth defense is taken by the defendants, that is public interest. I feel, and if I read all the judgments for the last 100 years in report of patent cases, Fleet Street Reporter, and Indian judgments also, which are excellent, I must say, best judgments given by the Supreme Court and the High Court. I say that the public interest, the defense of public interest is available to the party when there is a weak patent, if the court will feel that ultimately suit may be dismissed after trial and there may not be any chances of success of suit. Number two, if the court will feel that the patent has not been exploited by the inventor or the party concerned. Number three, the court feels that there are number of prior arts, and if the injunction is granted, the people will suffer. And number four, the court feels that sufficient material is not available. Sufficient drug is not available in India, and here is a Indian party which is ready-made having the products. Why not their products may be used? Some condition may be imposed, or compulsory license may be obtained, so that basically drugs should come to every patient. So in those type of cases, public interest may work, I personally feel. But if court is come to the conclusion that it is a valid invention, the grounds taken for revocation of the patent are bogus and infringement is deliberate, then basically the defense of public interest is not available at all. Then under those circumstances, injunction must be granted. Injunction must be granted. Now, these are the grounds of the invalidity of the patent taken before the court. These are the things we will discuss further also. The role of the court, and there are reforms already going on. But there are certain reforms are required before the patent office as well as before IPAB. I'm telling you that if we read section 25(1), That is basically opposition, first step of opposition, that it can be filed by any party from the entire world. Even NGO can file, press reporter can file the opposition, anybody can file it. The language of section 25 is very crucial. That is, I think that the amendment should be done in that provision, which mention if the patent application is published, the opposition, but the patent has not been granted, any person can file the opposition. But has not been granted is a very, these are the governing words in section 25(1). So it means unless the patent is granted, any number of opposition can be filed. We have been seeing while sitting before IPAB that the oppositions are being filed even at the appeal stage. And when the opposition is taken by the controller of patent for hearing, suppose initially because limitation is not prescribed for filing the opposition can be filed up to before the date of grant of patent. Any opposition can be filed. So hearings are taken place before the controller. One basically gets the clue from the hearing officer that he may not be successful. Another opposition can be filed by the Benami opposition so that hearing may be struck. In some of the cases, when the order was reserved and party is aware that he may not be successful in opposition proceeding, still next day opposition is filed and notices are being issued in routine manner. Now, basically, either the Parliament should change this provision because 25(2), the limitation is there for 12 months. But in 25(1), there is no limitation. And, there is a lot of delay in granting the registration of a patent. And I am also surprised that what is the purpose of signing the TRIP agreement and what is the purpose of bringing the amendment in the law if we are not complying, if the patent office is also not complying the heart and soul of the amendment, heart and soul of the TRIP agreement. In every case, I have been noticing that patent is registered in more than 100 countries, and the party in well-known companies, well-known countries, and the party is able to overcome the prior arts in those countries, and after argument, the patent is granted. Still, same prior art is mentioned in the examiner report as well as in the notice of opposition. It is a very serious thing. I am aware that that is not binding upon it. But the patent office should be very slow in raising the objection. Because if the prior art remains the same, which is already dealt by US court or some European court, then basically the objection should be very slow, and sometime basically it has to be waived if the satisfaction is there. But that is not the position. That is not the position here. So here delay happens, sometime 10 years, sometime 8 years, sometime 15 years. Then patent, if the opposition is dismissed, then the patent is granted, no doubt. When the patent is granted, protection is there before the court. But still, I am telling you, while as a judge of the High Court, when the opposition is pending under section 25(2), it is always in the mind of the judge that the patent is under cloud, still basically under the cloud. Although 64 can also be invoked for revocation, but when at the stage of granting the ex parte order, the judge has some problem, judge has some dilemma. He says, no, I don't know, something is pending before the patent office, it is an expert body. Why basically I should grant ex parte? Let the other side be there. The moment other side will come, lot of objection, and rightly so. I am not saying that they should not raise, they must raise. And if the opposition is dismiss. If the opposition is allowed, then remedy is 117 of the before the IPAB. IPAB, I have already mentioned that we are trying our best. We are trying our best in this level that appeal should be disposed of at the admission stage itself, because now chairman is there, technical member patent is there. We are also taking care about the action which should not have been taken before the patent office. They should have decided as early as possible. The controller must exercise discretion. The controller must give the reason when the second opposition under section 25(1) is filed, so that basically this malpractice should be stopped. So that at least I feel I've discussed with this thing with the retired judge of the Supreme Court, sitting judge of the High Court, as well as sitting judge of the Bombay High Court. At least author, that inventor or the company must have at least 8 to 10 years time to protect the patent, to enforce the patent before the court. Otherwise, there would be totally, basically, disappointment would be there. Disappointment not in India, in other countries also. They will make the perception that enforcement is almost nil in the high courts. And whenever the case goes, 18 years already expired, 19 years already expired, why we should file the action? In some of the cases, 10% appeals have been withdrawn before us on the ground that 20 years expired before the IPAB. And in many cases, patent expire during the contest of the matter before the court. There were so many discussions with us as far as this video conference is concerned. As I have already mentioned, all the matters of IPR matters are the commercial matter. Video conference, we should not feel negative about the video conference, because some of the people from the High Court and Supreme Court, they feel why not have the physical hearing in the IPR matters, or even otherwise important matter, commercial matter. I say the point is, we are dealing with very serious virus, and I have attended so many webinar judges conference in United Nations, WIPO, which is a part of the WIPO is the part of the United Nations, and people are happy there. There are advantages, there are disadvantages, but I feel that, and I am very much hopeful that video culture of video conference will continue, because sometimes it is very easy also. And I'm telling you that till 4:10, I was hearing the copyright matter. Mr. Tuljapurkar was arguing before me on behalf of Sony Entertainment, and he is in Bombay. I am in Delhi, and my members, one is from Hyderabad, one is from Chennai, and author of the copyright is in Bombay, Javed Akhtar. He was also present, and it is very easy in video conference to hear all the parties at one stage. Otherwise, one has to spend a lot of money, one has to waste so much time, and so many difficulties are there. Hotel charges here, there, So these are, no doubt, these are advantages. And as far as little bit disadvantages there, when the matter comes to the evidence, recording of the evidence, because when the evidence is recorded, body language, one can judge whether he is speaking truth or he is not speaking the truth. No, in patent matter, experts are recording the evidence. Now, the High Court has changed the system. And it is possible. I think it may also continue. It may be break for certain period to organize ourselves. But I feel that video conference will work, and it is very useful, and it should continue. I personally feel it should continue. Otherwise, it will help us. It will definitely help us. And with regard to the recent development I can share with you that Delhi High Court, as regard the patent office is concerned, IPAB is delivering so many judgments wherever we feel that unreasonable things are being done, where the rules are not complied with, where delay is happening, we are curing it. And we have already given 50-60 judgment, and we may also give 50-60 judgment more on this aspect. We will touch each and every point. I am nothing against anybody. We will be touching each and everything so that basically system in the patent office should be expedited and sufficient time should be given to the inventor to protect his patent in India. And every person in the entire world should feel happy that here is India. At least 10 years are given for the purpose of enforcement in pharma cases. And I personally feel pharma cases should be given priority. And I'm telling with you, we have a meeting. We have been meeting, and we have the sitting judges of the Bombay High Court. And I raised this point that in all the cases where the term of the patent day-to-day basis, so that basically the justice should be done to the inventor. If the genuine invention is there, why the party should suffer in India? If the genuine invention is there. So I'm telling you, you are aware all person, but still I'm telling you, Delhi High Court is process of framing rules which are already circulated, and I'm very much hopeful that they will do. Timeline would be fixed. You know, first hearing, so many things will be decided in the first hearing itself. Before first hearing, pleadings will be completed. Mediation process may also continue. Then basically independent expert, technical expert will be appointed on the first date itself. Issues will be framed, and in second date, affidavit and evidence would be filed and would be considered. The evidence can be recorded even by video conference. They are also proposing, and then in third hearing or fourth hearing or fifth hearing, final argument will be conducted by the court. And I'm telling you, other suggestions are there between the judges about the patent matter. I can only tell you that case management system they are also thinking of. So all the patent matter will be expedited, coupled with the injunction relief sought, and role of expert would be there. Every person will be neutral, and priority will be given to the patents which have a very limited life. So I feel that you will see that next 1 or 2 years, you will see a lot of reforms in patent matters, particularly in pharma cases. I give, because I have already mentioned that in the High Court, agriculture, chemical matter, and pharma cases are more than 90%. And every person is eager to decide, but sometimes some handicap is there because of one reason or the other. And future of this country is very bright of patent cases, particularly in pharma cases, because there is one reason behind it also. As far as the trademark cases are concerned, everybody is aware. No, people, there are so many judgments. There are thousands of judgments have come. No, people have understood. On the first date itself, the defendant is aware that ultimately he may not get any advantage, because the judge's law is quite settled by the Supreme Court as well as the High Court. But I see that next 5 years, after 2-3 years, you will find that after 5 years, there will be maximum matters of patent infringement in the High Court. Even they may cross the trademark matters. And ultimately, because earlier the figure was different in trademark matters, but now slowly patent cases are increased. High Court is very much concerned about it. Supreme Court is also concerned about it. And IPAB is also concerned about it. Whether myself, chairman, would be there or not there. But still, basically, I feel technical member is there who is expert. And we will see that every matter before IPAB will be decided within 6 months to 12 months. And the opposition under section, and I'm there, I will see that that process of registration before the patent office should be completed maximum 2 years. So these are my certain views about the patent matter in pharma industry. Good luck to you. Thank you so much for listening me. God bless everyone.
Thank you very much, Your Lordship. And it was a pleasure and very enriching address. And, it's particularly very motivating to know that Your Honor, as well as the judiciary in India, is looking at the inventors and the innovators get at least 8 to 10 years to enforce their patents. Looking at widening that space, that time period where they get an opportunity to enforce the patents. So without much comments from my side, we have one question, Your Lordship, from Mr. Arif Khan from UCB Pharma. He wants to ask if there is any scope for patent term extensions in India. So Your Lordship also spoke about a lot of reforms that India is looking at. So is this something?
Proposal can be there, but so far I've not got any clue. One has to verify, because in US, yes, patent extension, but I'm not sure. Basically, because evergreening is not allowed, I'm telling you. Evergreening is not allowed, because the moment I personally feel when the term of the patent expires, it becomes the public property. It will go to the public domain. Unless some amendments are there, some chapter is added, if some suggestions are there, and if anybody is aware, he can share with me patent extension. I'm not aware. I have not come across any case.
Okay, sir. So any other questions from participants? You can raise hands, or we will also request.
I can. Sorry, I can only basically give you some clue.
Yes.
That is only basically biosimilar products. After the expiry of patent, there are guidelines by the government of India in relation to biosimilar products. The injunction can be passed for biosimilar products if somebody is not following the guidelines issued by the government, even after expiry of 20 years. So I want to clarify this thing.
Thank you, Your Honor. So any further questions with Your Honor? We would be requesting Your Honor to be present at the end of the question and answer session.
Yes, I'm there. Don't worry.
So, thank you. So any further questions can be taken at that time. So over to you, Kavita, for the next. Thank you so much, Your Honor, for your presence today.
Thank you so much. Thank you.
Thank you, Namrata. Let me now introduce my colleague, Ravi Bhola. Ravi is partner and chairs patents practice of the firm. Ravi specializes in healthcare and life sciences sectors. He has worked with Sharing Law before joining K&S about 20 years back. He has extensive experience in handling patent prosecution, oppositions, and advisory matters. May I now request Ravi to please drive the panel discussion on patent eligibility in pharmaceutical industry. Over to you, Ravi.
Thank you so much, Kavita, and very good evening to all of you. Also, good morning to some of our friends who have joined in from US, and of course, some of our friends from Europe. Very good afternoon. Extremely delighted to moderate this wonderful panel that we have put together for all of you. Our first panelist is Dr. Dinesh Patil. Good evening, sir. Extremely delighted to have you with us today. Just to let people know that Dr. Dinesh Patil is Deputy Controller, Patents and Designs at the Patent Office. He's based out of Mumbai and is also the head of the office. Dr. Patil has played an instrumental role in drafting of the examiner guidelines for biotech pharmaceutical inventions in India. He's been in the administration at the patent office for almost 20 years and has represented India at various domestic and international fora. So very, very happy to have you with us today. Our second panelist is Dr. Harish Chandran. Harish heads up intellectual property team for India at Novozymes. Harish has been an in-house role for more than 10 years. But interestingly, before that, Harish was an examiner at the patent office. And I've been told that Harish had an opportunity to work with Dr. Dinesh Patil many years ago. Harish, extremely, extremely happy to have you with us for the panel. And then we have Dr. Andrew Custer with us. Very good morning, Andrew.
Morning.
It must be early in the morning that side.
It's later now.
and I know it's it's a Thanksgiving weekend, but I'm glad you're able to take out time for this. Really appreciate that, Andrew.
Of course.
So Dr. Andrew Custer is the director legal at Merck, MSD. He's been, of course, actively involved in prosecuting cases in US, but in the recent past has also spent some time looking at Indian cases for his organization. So I'm sure, Andrew will give a nice perspective, comparative perspective of how his experience been at US and how it has seen in India in recent times. Okay, so great. So maybe let me just, start with Dr. Patil. Dr. Patil, first of all, a big congratulations to the Patent Office for the kind of reforms that we have seen in the system in particularly last 4 to 5 years. Be it in terms of tremendous amount of digitalization that today we are able to reap the the rewards of some of those efforts which have gone in during this difficult COVID times, where as an ecosystem we are able to work so seamlessly with the patent office, be it from filing to prosecution to the maintenance of patents and even oppositions for that matter. And of course the kind of tremendous bandwidth that has come in terms of new set of examiners who have come in. A lot of experienced examiners have become controllers at the patent office. So overall, I think in terms of streamlining operational side of it, it's absolutely fantastic. So big congratulations to you and your team for those reforms. And I must tell you, the people we meet across the world have recognized and acknowledged the significant positive change that has come in, which is wonderful. Now, even the question that I often come across from people in the industries, with this wonderful young lot of examiners, there could always be a challenge in terms of how do you ensure uniformity, considering we have 4 patent offices which can add to the complexity. Looking at that kind of challenges, how do you kind of deal with aspects around uniformity of examination, maybe particularly towards pharmaceutical, biotech, biochem inventions, and some of the other initiatives that you may plan to take to deal with issues, because it'll always be a difficult balance to strike. You have a quality issue vis-a-vis quantity issue. How do you deal with that, sir?
Actually, what you said that we have now 4 offices, but I can tell you that although we are sitting at 4 different locations, and you may be aware that earlier time we were dealing with some cases which were filed at, let's say I'm in Mumbai, so I was dealing only Mumbai cases filed at Mumbai Patent Office. Somebody who is sitting at Delhi was only dealing with the Delhi cases. But since 15, now we have merged all those patent applications in a single queue. And right now, whatever new applications people are filing, they have a single queue of filing and at the same time request for examination. So virtually now there is only single patent office, not at 4 different patent offices. Of course, the people are sitting at 4 locations, and as you said, key inconsistency or for bringing the consistency, as you may be aware that time to time the patent office has tried to issue certain guidelines for having the consistency. But you may be knowing that there was a lot of pendency earlier time, and to liquidate that pendency was a priority. So now this removing inconsistency and to improve the quality of that all aspect, not only the examination but even the grant of patent, and I expect not only quality from my office side but from the attorney side and applicant side as well, because quality aspects are not only from the one side. filing and prosecution of applications, having good disclosure in patent specification, everything counts for the quality. So that aspects we are continuously monitoring, we are working upon it as per, and recently we have taken a lot of initiatives for amendments into the rule. You may be knowing 2016, 17, 19, and recently in 2020 we have two amendments right now relating to some Form 27 related issues or relating to a reduction in fees for MSME sector. At the same time, we have modernized the patent offices. We have the state-of-the-art facilities, computerization. Now, this video conferencing. We are conducting all hearings now, almost all hearings over the video conferencing module. We have a good connectivity, broadband, everything. Same time, we have improved the manpower. If you compare the manpower in 2015, we have 183 examiners. Now we have 673 posts and 610 examiners in place. Similarly, 89 controllers were there to look after all these disposal matter, because examination at examiner end and disposal at controller, a two-tier system. So that strength has gone to 250 now. So controllers manpower has been increased, and government is again thinking to further improve the quantity of examiners and the controllers. Similarly, these IT initiatives, if you see, for expediting, for quality purpose, for giving better services, everything has been now electronically processed, right from filing. Now all the patent applicants who are filing their applications through their attorneys, now it is made compulsory, as you know, that patent agents or patent attorneys need to file online only. So as a result, we have achieved 91% online filing. So because of that online filing, the online processing is also facilitated, and all e-filed applications, all communications we are receiving by emails. At the same time, you may be seeing that along with examination reports, the grant certificates are also being issued through the mail. At the same time, SMS alerts are also issued that your examination report has been issued, timeline is this. Then you have got the hearing intimation, then you got the hearing patent registration certificate into your email. So a lot of IT involvement we have made, and we are trying to further upgrade that using artificial intelligence in the near future. As you said, what we are trying to improve further. So there are the plans to use the artificial kind of the things, right from screening of application, classification, and maybe for further aspect of processing that applications. As you know, we have also taken care of this expedited examination in certain fields, startups, or the applications which are selecting the India as a ISA or IPA. Certain government entities we have allowed, female applicants we have allowed. Certain sectors can be notified. Right now there is no notification, but there is a provision in Rule 24C that certain sectors of vital importance, if comes before the government can notify those sectors for expedited examination. The startup initiatives by government of India, SIPP scheme is there. Startups are being facilitated by providing the facilitators. Their fees are reimbursed by the patent office. At the same time, we are also making a lot of awareness issues, not only for the generation of IP, but for respecting IP as well. You may be knowing that we are right now running a pilot scale project of PPH with the DKPTO, and maybe there are lots of proposals from other countries to have that kind of arrangement, and government is working upon it. So as a result, if you see, because of this overall process engineering or amendments into the rule, then facilitation of this computerized processing in patent office, so we have achieved a considerable rate into disposal right from examination. If you compare the examination in 2014-15, we have only examined 16,800 some applications. Right now we are issuing 80 to 85,000 examination reports. If we compare the grant, only 6,000 we have granted in year 2014-16, 15-16. Right now that has gone to 25,000. And overall disposal is now matching with the filing. If you see the filing in 2020, 56,000 patent applications we received. At the same time, disposal is 56,000. So that filing and disposal is matching. So liquidation of backlog we have taken. So in summary, if you see what is the impact of these overall reforms in the patent office, 91% e-filing as compared to 14-15. Rate of examination up by 375%, 16,000 to 80,000. Disposal is by 155%. Similarly, the bigger concern was waiting period of getting examination report. That was around 72 months in year 2016, near to maybe in October, November. That has come down to 12 to 13 months. Because 12 to 13 months, because we have a different kind of application, pharma to biomedical to engineering. So in some cases, if you see the pharma cases, we are quite ahead now. Less than 12 months, we are examining the requests of examination which were filed in this year only. So that has gone from 12 to, so by next year, December 2021, it can be 12 months just, which may be at par with the top 10 leading offices.
That's wonderful.
And, yeah, so these are all efforts we are taking, and we are really concerned about what Dr. Honorable Justice also said, that these delays at patent office level are also causing some harm to the applicant. So we are taking care, and we are in the process of dealing with that.
No, absolutely. I mean, fully endorse that. I mean, and I must, tell you on a lighter note that because of this whole lot of initiatives that Patent Office took, we attorneys also had to up our game to, match the pace at the Patent Office.
Certainly, because you will get all the office actions, and you are also supposed to gear up to meet the requirement within that 6-month period.
Absolutely. So fully endorse that, in the ecosystem, every player has to play its own role to help the ecosystem grow.
I rightly said you that quality and quantity and everything, this curtailing delay is not only on part of patent office, but it will also on part of applicant. They are also supposed to gear up to meet with all this, because it is my experience in these multinational companies, they generally use all the last moment timelines. Suppose request for examination from date of filing 48 months. So it is my experience that they will certainly file at the end of 48 months. So after the examination report, they will make a reply to examination report on the very last date, or even they will try for extension of that 3 months. When it comes to the patent office, then after looking at if there are any outstanding issues, if I offer a hearing, they will try to get extension, maximum extension. So this delay is not, certainly it is because of the use pendency and less manpower in the past, and because of this modernization was not there. So patent office was also responsible. But if you see all these aspects in detail, you will come to know that other side is also responsible.
Right. Now, coming into the, deep diving into the subject matter for our panel discussion today, which is about patent eligibility, maybe I'll start with Dr. Harish on this. For example, Section 3, of course, talks about the kind of inventions which are not patentable under the law. For the biotech, biopharma, pharmaceutical space, for example, if you look at provisions around Section 3E, which talks about not patentability of mere admixtures. Now, in your organization, for example, I know you guys deal more with enzymes and inventions around that, and I'm sure you'll have consortium of enzymes and a whole lot of biotech happening around it. What's been your experience around, kind of inventions, and how do you deal with issues around mere admixture-based, provisions under the law?
I think that is one of the most common objections that we have whenever the claim is on a composition. I think that's the first objection that we get to see. Before I start, I think I should congratulate the Patent Office for when I was an examiner to now, there's such a big change. And I think all the IT initiatives have really borne fruit. With the current 3E that we see is sometimes the examiners insist on examples, and a lot of these examples ask for comparative data. And we sometimes see that there is a difference between the offices in terms of how they interpret the composition claims in respect of 3E. Is it what kind of synergy is needed? If there is a composition and an excipient, then can we show that there is an increased effect of the composition, or there is more bioavailability or more delivery of those compositions? is that enough, or is there something else data? So we see some inconsistencies between examiners and between offices in the way they interpret these sections. And for us, it's more like if we get a good controller who can understand the subject matter and understand the complexity behind the technology, then it's easier for us to explain with data. We can explain the technology that we are dealing with. If it's an examiner that is not so familiar with the technology, I think the bar is higher for us to kind of explain things to him or her. And that's where we find a lot of challenges in terms of how to prosecute objections that are related to 3E.
Okay, that's helpful, Harish. Andrew, I know you've seen how the US system works, and of course, in the recent past, you've looked at some of the provisions, including Section 3E, which talks about mere admixture and associated requirements under the law. What's been your experience, and what kind of strategies you may employ to deal with the issues around this?
So it's I mean, explanation. I mean, as Justice Singh said, explanation is, and I think so, to a certain extent the burden can be on the the applicant, right, to really try and explain sort of what's going on, even at the patent office. And I think I think that's important, but again, familiarity and sort of just general experience of the examiner can be very, very helpful. And to really kind of help and explain what's going on, why is this admixture important? And perhaps, I mean, it did occur to me as Harish was talking that perhaps it's one of the things that might be happening is, to a certain extent, the High Court's decision, the old Novartis decision about what is efficacy. That kind of concept may actually creep in, right, to the examiner's thinking, and may sort of taint it a bit depending on what's happening. I find that a lot of one of the things I can I'll probably mention later is there's a sort of a, I mean, and this has happened in both the U.S. and in India, right? There's sort of almost a conflation to a certain extent of determining patent eligibility with using inventive step and using novelty. Those are sort of aspects of that creep into patent eligibility, and that's been it's a huge problem in the U.S. still. I mean, the expert courts, the Federal Circuit is trying, they're experts, and they try and sort of push back on some of the Supreme Court decisions along with the patent office, but the law is muddled, and it's challenging. I have to say that India seems to be, at least with some recent decisions and oppositions and things, they've shifted the analysis, and they say up front what is inventive, is this inventive, is this novel? And to a certain extent, the eligibility is sort of falling into line with that. And I think to a certain extent, it actually makes more sense. So to the extent you can kind of keep the legal concepts separate and, just continue to train, and instruct examiners as they gain experience, I think things will improve. I mean, look, the U.S. has, it has a long IP history, but even still, the examiners, you do see some variability in examiners and how they treat patent eligibility in the United States. And as they get guidance certainly as they get guidance and memos from, from the top of the patent office, things generally improve, but you still see some variability. So.
True. I mean, in US, 101 still, I think, continues to be a bit of a moving target.
Yeah.
But fully agree that, these are evolving times. And, I'm glad, Andrew, you touched upon enhanced efficacy element, because no discussion on pharmaceutical patents in India be complete without talking about Section 3D. And, of course, the famous Novartis case. So, of course, a lot has happened since the time we had the Novartis case, and things have evolved by way of jurisprudence to some extent. Of course, it will be great to see more clarity as we go forward. So maybe Dr. Patil, I'll ask you, I know, I mean, I get the feel that you've been involved in the system for such a long time, and you've seen the Novartis case, very from the close quarters. And of course, you've been, as I said earlier, instrumental in drafting some of the guidelines that we had on these topics. So what's your view around, Section 3D, the whole issue around enhanced therapeutic efficacy? And some of the questions that we often face, for example, is that how do you deal with a situation where the focus of the invention is on, more stability for the molecule, for example? How do you deal with those issues with Section 3D? How Section 3D will be dealt with in those kind of inventions? Over to you, sir.
Actually, before directly going to Section 3D, as Harish and Andrew was talking about that Section 3E and Section 3D. In case of Section 3D, at least there is an explanation into the section itself, and which talks about there must be enhancement into the efficacy. So that is a guiding factor, at least for you people as well as to argue or me to object that it has a less, it has not established, the application has not established the improved efficacy or this. But in case of Section 3E, as Harish also pointed out, that there is a variation into the interpretation, because they said that mere admixtures are not patentable, and we, by maybe some case laws or maybe some practice had evolved across the world, we correlate that mere admixture with a synergism. If it is synergism is there, so that will not be treated as a mere admixture. So this kind of explanation is not there. So the basic difference between Section 3D and 3 is that there is explanation in Section 3D itself, that what is the way out to deal with those kind of objections or those kind of inventions. But here there is no such kind of a guideline. Even this synergism word is not itself into that particular provision. And moreover, at least now recently we have this Novartis case in case of Section 3D. But case laws in case of that Section 3E are not too much evolved or may not be that much known to the people. So at least some guiding fact. If you see the guidelines also, guidelines, we do not get any positive example to cite in those. At least it may not be positive for the applicant, this Section 3D case and Section 3D matter and Novartis, but at least there is an example case law to quote into the guidelines for having a consistency. But in case of this Section 3, very less information or case law kind of things are available. So if that kind of things comes, that explanation into the guidelines or maybe the judgment itself can be a guiding factor to have a consistency. And about the Section 3D, which is now most talked, debated everywhere, whenever the pharma patenting or Indian Patent Office comes around. But these applicants or the most of these pharma companies from abroad always raise that we are using Section 3D very often, or maybe they talk it unnecessarily. But at the same time, we are also receiving some kind of a reports or representation from some civil societies. And there was one report which says that despite of very good provision into the patent law Section 3D, which categorically clarifies what is patentable and what is not patentable in case of new derivatives, because explanation is there. But despite of all objection, that report says that majority of patents, that is 72% they have quoted, granted to the pharmaceutical patents are secondary patent. It means that they are not, some people applicant claim that these are new chemical entities. But as per this particular report or finding, they have cited cases also, list is there, that they are saying it is not a new chemical. These patents are not for new chemical entities, but these are the secondary patents for extension of the term of that earlier molecules. And only 15% which patent office has granted in the field of pharma are scrutinized or subject to elaborate scrutiny as per Section 3D of that. So there are always two different kinds of views. A company is saying that we are not properly using Section 3D, whereas the other side, NGOs and all those civil societies are saying we are not looking at Section 3D properly, but we try to give that kind of a balance. And as you know, that Section 3D validity was also questioned or challenged in the past in that Novartis matter, right from High Court to the Supreme Court. But Honorable Supreme Court. that is the law of land, upheld that that particular section 3D is valid as far as the TRIPS agreement, obligations and the TRIPS, and thereafter the Doha declaration is concerned. So there is no question that it is, people also argue that this particular requirement to justify the efficacy under section 3D is an additional requirement over the article 27 of the TRIPS. But Ravi, if you compare that, article 27 talks about novelty, inventive step and industrial applicability. So in my experience in the patent office, I have also seen the prosecution of the patent applications in different patent office, because national phase applications which I am dealing here are also done in other offices. That I don't think so. What we are requiring under section 3D to justify enhanced efficacy in case of this, particularly therapeutic efficacy in case of these pharma molecules. It may be some other efficacy in case, people also say that it's a technology specific section, but I don't think so. Because law says improved efficacy. If it is some chemical molecule, it may be a catalyst, that time there may be some other kind of efficacy. But that Novartis case was related to a pharma matter, and that is why the Honorable Court has directed that since it is a drug molecule, so it is a therapeutic efficacy. But I don't think so. It is only restricted to a particular sector. It is applicable to all kinds of applications or all fields of technology. Coming back to that aspect, whether it is an additional requirement or not, I don't think so. Because if you see the similar requirement or data which you justify here, either in case of section 3, establishment of synergistic effect, or here establishment of improved therapeutic efficacy. This kind of the data are only required to justify inventive step. And Honorable Justice is also there. He's having more knowledge about the all Indian evolution of Indian patent law. If you see the Patent Act before the amendment of 2002, there was no determination of inventive step in the examination. It was only at the opposition and revocation stage. Novelty, and we were seeing the applicability, and that too manner of manufacturing was there. So after 2002, definition of invention becomes very wide. So any product or process which is novel, inventive, capable of industry. So section 3 was there that time, although we were not directly evaluating or determining inventive step. So to cope up with that requirement, there was section 3 as such. And particularly for pharma, if you see section 3 was there, 3D was also there. It was amended, of course, to clarify this by way of explanation. So these kind of the requirement which are there in section 3 are nothing but a requirement to establish an inventive step. And if you see the explanation provided there, rather it helps the applicant. If explanation would not have been there, it might be the great problem for the applicant to prove how that a particular new derivative is not a known chemical entity or something. Rather, the law itself gives very good guideline that you prove before the patent office or maybe before the courts that it is having this improved efficacy. So you have a passage to get your patent out of it. And that may be the reason that we are, despite of section 3D objections, we have passed 72% applications as per that report. We were objecting, but after establishing that, certainly the patents are, and you may see the granted pharma patents, you will see there were objections, but so many patents are granted.
Wonderful.
And the issue which people are talking that it is only India specific requirement, but that the similar kind of secondary indications or secondary considerations are not only considered in Indian Patent Office, but US, I have a very good case law, Pfizer versus Apotex. There they have also considered this kind of improved efficacy, synergism, or this kind of secondary indications to consider the inventive step. So I don't think so it is a additional requirement over and above the TRIPS. It is only coming under the inventive step, and further we have that separate provision. So that helps the applicant to in fact justify if it is improved in terms of efficacy.
Right, sir. That's very helpful, sir. Harish, you may have some thoughts around section 3D and your experience, like, Andrew briefly touched upon it. So any thoughts from your end?
Yeah, so I think the whole question boils down to what is a new substance. Many of the times when you look at antibodies or sequence related claims, if it is a protein or a protease, right? So it is a protease. There are lots of, but then the proteases are actually defined by the sequence. And if there is a difference in the mutation, so it is some of the times that we hear, or when we look at cases that's being prosecuted, then it's kind of classified as a new form of a known substance because protease is known. And so anything that falls is classified as a protease is kind of considered as a new form. Whereas the section 3D clearly states that it's not, the difference is in the salt or the others, right? But there's not much clear definition on the biological molecules per se. And I think sometimes we get into that kind of a situation where there's a dispute as to what is a known substance. So what is the closest prior art that is a known substance? And how does your protein molecule or your sequence molecule differ from the prior art that is the known substance, and how do you relate to it? So we have had examiners who are very rigid in the way they interpret it, but then we have also had examiners where we have explained the process and they have understood. So the clarity is less, but I think there are examiners where you can actually help through and get through. But with regard to section 3E, I think we always get into this challenge of what is a mere admixture. And I think there was one recent IPAB decision that said that for 3E, even if one component is novel, then you cannot ask for synergy. I think that's a very good kind of a guideline that is there. And I hope all the examiners at the patent office kind of agree and follow that guidelines, that if the applicant is able to show that in a composition there is one element that is novel, then the examiner cannot ask for a lot of synergy or application data in order to be convinced. So I'm hoping that that can be some kind of a presidential kind of a decision that we can all refer to and kind of agree on the guidelines. So that's where I think we have these challenges with regard to the 3D plus the 3E.
Thank you so much, Harish. I would have loved to, take up more questions from all of you, but unfortunately we have, run out of time. May I just take the liberty to ask one question to Dr. Patil quickly, because there's something in the pharmaceutical industry we, often talk about is, this sensitive issue around compulsory licensing. And, we may have just 1 or 2 minutes, Dr. Patil, but if you can just broadly give an overview of what's the current situation around that in India?
So, Ravi, if you know that as of now, only we received to my knowledge, 3 applications for the compulsory license, and only one, which was in 2012, relating to that Nexavar. That was the only applications which the patent office allowed and the compulsory license was issued. Thereafter, subsequently, 2 applications were there for compulsory license. Against that, maybe dasatinib and some gliptin molecules were the anti-diabetic, and second one was again anti-cancer. But the patent office itself has analyzed, and even those cases have been rejected. Those applications for compulsory license have been rejected because the prima facie case was not made out. So it is not something out of proportion that every time this issue comes that India has a provision of compulsory license and those 3 grounds and all, and now any innovative molecule which has been granted and tomorrow there can be a compulsory license. It is not the fact. Only one applications after this product patent regime since 2005, only in 2012, and that was a very solid case, and there was a ground established by the applicant for compulsory license, and that was only allowed. But thereafter 8 years has gone, not a single compulsory license application has been allowed, and I don't think so it is having that much problem as people are echoing around that compulsory license is a threat to the innovators, threat to the patentees. Not like that. It's a very clear matter.
Right. And as I understand from the recent annual report issued by the Patent Office, as of now, there's nothing really pending, right? That's the sense I got from the annual report.
Because if you see our recent annual report, 18, 19, there is no any case which we are showing that we have a pending with us. So no compulsory license.
Thank you so much for those inputs. And, as I said, I would have loved to have this conversation going, but unfortunately, we have run out of time. So thank you so much to all the three wonderful panelists for taking out time for this. And please stay back for the Q&A that we may have another half an hour from now. So Kavita, over to you.
Thank you, Ravi, and esteemed panelists. So our next speaker is Andrew Jenner, Director General, INTERPAT, and Mogens, Head of Patents Department at Danish Patent and Trademark Office, who will be sharing global perspective on India's pharma sector, opportunities and challenges. So Andrew is Director General of INTERPAT, a global trade association of chair IP councils from the biopharmaceutical industry that seeks create sustainable innovation ecosystems to advance human health. He is also the executive director of a strategy and policy consultancy based in the UK. He was previously the executive director of corporate strategy and legal affairs at the International Federation of Pharmaceutical Manufacturers and Associations. It is called IFPMA, based in Geneva, where he was deputized for the Director General. So I will also introduce Morgan, and after that we can start the presentation from Andrew. Mogens is based in Greater Copenhagen area and serves presently as Head of Department at the Danish Patent and Trademark Office. Mogens graduated in biology from the University of Copenhagen and entered basic and clinical research and later R&D and consultancy for big pharma and other industrial partners. Later years, Mogen have been engaged in public administration, management, and organizational development. Mogens heads a department at the National Patent and Trademark Office responsible for national and international patent registration, as well as international projects within capacity building, organization and advisory. So may I now invite Andrew to start the presentation. And for this, I'll request Lex Witness to upload share his presentation. And Andrew, you have 15 minutes.
Thank you very much, Kavita, and very good afternoon, good morning, everybody. And it's a real pleasure to be with you all today. It would be lovely to be in person, but maybe next time. This is definitely the next best thing. And I think just highlights the great conversation that we've had today. I think I've learned a lot, and I very much look forward to continuing our dialogue together. What I thought we would do today, and if we go to the next slide, is have a quick look at what INTERPAT is. I know some of you are familiar with us. I'll probably be a little bit quick on that front, given our time. Then to just give a snapshot of our perspective on the India's innovation ecosystem. What kind of things do we see that are happening there that are exciting? And what are the kind of challenges that we can try to overcome together as all countries are facing as they try to nurture and grow their innovation ecosystems. So if we go to the next slide. So the mission of INTERPAT, as Kavita mentioned, is really about to create sustainable innovation ecosystems. That's really what we're looking for the benefit of global health. We are very interested in the role that is played by intellectual property in that, but it's fair to say that we're also looking at more the wider environment. How does collaboration take place between different entities within the local context and economy? So there's our mission. And maybe if we go to the next slide, I'll just quickly highlight some of our objectives. One of the things that INTERPAT does is that we try to build consensus around innovation ecosystems in terms of our understanding of what that ideal environment looks like. Some people think that the pharma industry are all groupthink. It's actually very challenging to get over 25 companies to agree on certain elements. So that's something that the role that we play right down from CEO level to operational level. And in fact, I'm presenting to our CEOs just next week on IP. The second thing that we do is that we see ourselves really as an incubator of new ideas and initiatives. If you're familiar with WIPO research, which is about the development of products for TB, malaria, and neglected tropical diseases. We've also, the genesis of PAT Informed was also within INTERPAT, and then developed further by IFPMA. So we see ourselves as having that role within the industry because we comprise the chief IP counsels of the companies. So all of that practitioner experience and expertise we like to bring to bear. And what we've seen actually, and this goes to our third objective, is that there's been a real desire from countries to have that peer-to-peer dialogue, so that we're not just looking at the policy questions on the high level conversation that is important, but also how do these things operate in practice? Because sometimes legislation that's not perfect, we can implement it in a way that's mutually beneficial for all, and so on. So that's where we're seeing that there's this massive growth and interest in engaging with INTERPAT to have a look at the practical implications of legislation and how we can improve systems for local and global innovators. And one of the other programs that we're developing is robust empirical evidence. We feel that it's important that industry not only says what we think, but evidences why we think the way we do. And if we go to the next slide, one of the things that we've been doing in the Latin American region is to go through the different countries and look at by case study examples as to how are they doing in terms of their innovation ecosystem. We did one in Argentina, Brazil and Mexico. And just to highlight a couple of things, we launched the Brazilian report in the lower house of Congress just before COVID. So we were very fortunate that it was 2 days before virtually the global lockdown. But it was fascinating for us to see how the strong ministerial interest in seeing how Brazil as a country measures up with other countries of a similar level of economic development, but also how they're benchmarking with other countries from the OECD realm. And that's essentially the process that we follow. We developed this methodology using an economic consultancy, Charles Rivers Associates. We look at the empirical evidence on the ground. What are local academics writing about the country? What are others writing about the country? Then there's an interview process. So we try to interview people from the full range of perspective, both academia, government, and industry, large and small, and then produce a report to say, these are the kind of things that we think are very positive, driving change in the country. These are the kind of things that if the country was to make a choice to change, then they would expect to see acceleration in those areas. Just to highlight down the bottom there, we've got an ongoing dialogue with the Supreme People's Court in China. And so very interested to hear Justice Singh's perspectives on how things operate in India. Again, the Supreme People's Court very keen to understand from a practitioner's perspective, how is the system working in China and how can they improve it? And again, very technical discussions. We welcome each other, but we really go down into the nitty gritty of how these things operate in practice very, very quickly. And our engagement with WIPO, the European Patent Office and INPI are the same. In fact, just last week, I was presenting to the Director General of the Patent Office in Singapore and building a collaboration there. So moving maybe on to the next slide, and I'll pick up the pace. Kavita, don't worry. This is just a framework to see what is it that India has been doing over the last period of time, say 20 years, in the innovation space. I won't dwell too much on this. Maybe we'll flip over to the next slide for time. You know this piece very well. But on the next slide, I think we really do want to acknowledge the progress that has been made in India, particularly around digitization. As an ex-patent examiner and moving the UK over from paper files into electronic files, I can certainly feel your pain given the size of the country and the geographical split that you have within the office. And we applaud your efforts in that regard, especially in recruitment and training. But one thing that I really wanted to highlight here from a global perspective is that these peer-to-peer conversations that the IP office is taking forward with practitioners is really powerful and meaningful for us and for many others outside our industry. That dialogue is incredibly helpful to learn from your perspective why things happen the way they do, and that helps us then to modify our behavior accordingly, which is important as Dr. Patil was mentioning, but also that we can explain some of the problems we see in the system. and how can the system be improved in a way that's helpful for all innovators, wherever they come from or whatever the technology areas that they're working in. So we would just strongly encourage that peer-to-peer conversation to continue, and this kind of platform is also great for that. One thing that we have looked at when we did a bit of research into the India landscape is the technology transfer offices that have been established. They're relatively new, but they're absolutely vital if you want to think about how do you take ideas and research into the commercial realm. We've seen that technology transfers really cement the collaboration between global industry and local industry for benefit, not only for economic development, but also for societal benefit, focusing on the issues that that particular country is facing. So we've just done a launch of a study in Mexico, and I was speaking last week in the annual conference in Mexico, where we had ministers of health and trade. And we were saying very diplomatically that the defunding of technology transfer offices in Mexico because of the new administration's approach is potentially harmful for them. And they were making good progress, but it's so important that countries have a coherent innovation strategy that doesn't change dramatically with new administrations. That golden thread which ties all of these things together and maintaining it is so critically important. So maybe if we go to the next slide. So when we've compared India internationally, you can see there that if you see in the black, that's a positive thing. We see that in India, there are many of the components that are in place that are recipes for success in driving innovation within the biotech sector. There's strong universities. I think it's clear that education at a tertiary level could be increased, but the universities that you have are good ones. There's a good amount of collaboration that's happening, both in relation to as you compare yourselves to other middle-income countries, but also as you compare yourselves to the OECD. And there are certain areas that could be developed further. So, for example, in clinical trials, India at the moment is not the place that many companies would want to do clinical trials at the moment when compared to other countries. And this is where what we're saying to countries is very candidly, it's your choice as to where you want to become a center of excellence. And it's probably fair to say that not every country wants to be seen as the center of excellence for all areas of the supply chain. But if you do have an ambition for that, these are the kind of things that you can put in place in order to catalyze that kind of activity. And RDP is one of those. We've already talked about Article 3D in India. Again, a lot of incremental innovation has great value. And I think many health practitioners can identify that, as we're talking about COVID, having heat stable formulations of a vaccine could be a huge advance in terms of patient benefit, but also massively reducing cost of transportation, given that we have to keep some of the vaccines at minus 70 degrees centigrade. And of course, the generic industry, it's fair to say, many companies are evolving into that value capture model that we would expect them to do, that they are filing globally within the key offices. I know that India's PCT filings is going up. When we see Indian company patenting activity in the United States and Japan, it's also very, very strong. So these are the kind of environments and factors that companies will see which countries are making the policy choices to attract that certain degree of activity. And what countries are very nervous about is that with the global village that we're living in at the moment, is keeping innovators locally, working on local issues for global benefit, rather than seeing your innovators moving to other markets where there's simply more opportunities in order to drive progress. So if we go to the next slide. So we just did some, we wanted to highlight some case studies that we did in other countries. I know that time is quickly going, and happy to share all this information with you. But China is a fascinating case study when you think about what the Chinese government has been trying to drive at a domestic level in terms of attracting FDI, particularly in the biopharmaceutical space. And what we're seeing there is that as they continue to develop, the local voices are becoming, if you like, the vehicles for change within China. And that's something that INTERPAT is very keen to help, is to provide empirical evidence, share our experiences and our expertise so that the local voice can be the principal vehicle for any change that needs to be happened. It's not generally acceptable for us to tell you and order you what we think your environment should look like. We want to hear from you how your environment operates and then guide you in terms of where we think low-hanging fruit could be for long-term development. And I think we see that as a very important co-creation model that we've adopted. And this is why we've got these platforms that we have with Singapore, with China, and with Korea. And these case studies are fascinating because the evidence shows the significant positive development in economic value-added activity stemming from a coherent strategy and legislative change, some of which stem from IP laws. So if we move to the next slide. This is just an example, and I won't go this into detail with you, but when we finished our detailed study in Mexico, these are the kind of things that we will drill down into. Mexico has a new IP regime. You may be familiar with it. And we're saying that if these measures are implemented effectively, these are the kind of things that you can see happening. And if we maybe just go to the next slide, this is relating to both basic research gains, clinical trial gains, employment gains in the pharmaceutical sector, as well as patents granted by local offices, which is an indicator of activity. So that's what we try to do in Mexico. And then we try to put a numerical figure to that. And again, we've had our methodology peer reviewed, so we're comfortable that it's as accurate and as forthcoming as it can be. But it does address the concerns around, for example, if you implement RDP, regulatory data protection, will you see potential loss of jobs within certain industry sectors? What we've found from our case study evidence, you don't lose jobs, but jobs will change. The market will adapt, but the jobs that you create are more value-added jobs, more white-collar jobs, if that is the aspiration that the country has in order to further its economic development. So maybe if we go to the next slide, and I'll finish here. Hopefully I'm on time, and very much look forward to continuing the conversation as we go forward. But just to say, from our side, we think India has many of the key assets to be successful in terms of life science innovation, and a pro-innovation policy framework that India has is the golden thread. But it has to be effectively implemented. There can be some very useful legislative changes that India could consider if it want to attract a certain type of innovative activity. But being able to have those collaborations between local companies and global companies and building that framework of trust is critical. And that's a wonderful role that the government can play in driving those mutually beneficial collaborations. And from an INTERPAT perspective, and I'll finish on this one, we're very keen to hear from you as to what you think our companies could do better in terms of our filing strategies or our operations in India. But also, we're very keen to share our perspectives, to share our experiences, our expertise with colleagues in India, so that it's a mutually beneficial exchange that we try to find those golden nuggets that will accelerate India forward, because all countries seem to be very interested in these type of discussions because they don't want to be the ones that fall behind. And there are some great case studies from countries, and we can see that we're not necessarily going to copy what other countries have been doing, but what is exciting is to extract the best practices, see if that works, and how could that be adapted in the Indian context, and then grow it organically to make sure that we're getting buy-in from the people that we're trying to serve in India. So again, thank you so much for the time, and more than delighted to take questions when there's Q&A.
Thank you, Andrew. Really appreciate it. And I see, there is a hand raised. So my request is that let's finish the next presentation and then we open it for the Q&A. So may I now invite Mogens, Baltsen, and request Lex Witness to share his presentation. Thank you.
Yes, please. And thank you, and also thank you, Andrew, for a very interesting presentation. And on behalf of my institution, the Danish Patent and Trademark Office, I would certainly like to express my my gratitude to participate in these interesting discussions here. Could we bring the presentation on?
Yes, Mr. Mogens, just give us a few seconds. We're setting it up for you.
Okay, very good. So what I'll try is to present a brief on the pharma sector in regard to innovation and IP in more general terms, and I would say partly taking from an institutional point of view.
Akshay, okay.
Over to you, Mr. Mogens.
Okay, very good. We'll bring the next one on, please. I promise I have only 4 slides, so don't fall asleep. Thank you. Okay, so first, a brief into what is usually considered as important conditions for the pharma sector at the, you could say, the more societal level. First of all, the healthcare sector itself. It's obvious that the pharma sector is driven by societal needs, and I believe this should be remembered at all times. Also, that the sector benefits a lot from the close relation to practices and what we used to say experiences in patient-related routines in general. So the healthcare sector is important. Education, needless to say, it's important to have biochemists, doctors, engineers, and so forth, but also nurses, laboratory technicians, and all academics to support registration, legal matters, and so forth. What is known is that investments, or especially high-risk money, is important for at the R&D level and discovery level of this sector, and it's increasingly important. And I think there are some studies out there that can show a tight correlation between the amount of high-risk money and the extent of success in this sector, or at least in R&D and ramp up. I put an asterisk to the next one, the regulatory approaches, because this is really what I know a lot about, and then what the most of our talks today will deal upon. Now, the pharma or sectorial development should work or works in parallel to how regulatory authorities optimize the balance, you could say, between societal expectations and business needs in more general terms. In this regard, not only IP, but certainly also medicinal approval and marketing authorities are important. So it's not all about IP when we speak about regulatory approaches. And also, I think we should remember now, we had a very interesting presentation in the beginning that regarded enforcement and enforcement structures, but the whole food chain in IP should be considered here. Also public awareness and definitely enforcement measures. So not only registration purposes. Okay, and the last one, I think also something that we have touched upon today, namely the extent of international integration, because what at least from our perspective, what we see is increasingly important for the sector is the ability to work international, and to that extent, or to this end, the Indian companies must comply to increasingly extent to the international recognized standards in terms of regulatory stuff and technical standards as well. Okay, so this is the next one here. the trending areas, and I won't go into detail to this. I think there are more experts in the panel on these things. But just in order to emphasize that I put an asterisk to most of the areas, because these areas with the asterisks are heavily influenced by what we could call innovation or innovative solutions and new technologies in general. So if you take out the consumer healthcare drugs or the over-the-counter drugs, which I know that India are doing well within, all the other areas, they rely very much on innovation and innovation support in general. So this should be taken into account. So let's go to the next one. Thank you. So taking a look at the pharma sector more in regards to how they face up with IP and patenting in particular. First, operating the IP system. We think that domestic IP system or domestic IP stimuli in general advances the international progress and success. That's another way to say that the better your own systems work, the better your prospects or your company's prospects abroad. And this is a lot about international harmonization and compliance to the international standards also. Adaptability and harmonization in general in terms of patent law and practices in the administration, of course, also important. Legal certainty and support by the domestic IP societies is definitely, or should definitely be considered as an important part of the spectrum of services in general. So how should business, as I put up here, how should business needs and regulation and what we call administrative support go together in regard to IP? Well, there are different needs here. First of all, it should be remembered that small businesses, R&D, spin-outs from higher education and universities and so on, obviously have other needs as compared to big pharma. Small companies needs heavily support also by the IP office for qualification of ideas and first of all a cheap or an easy way to enter the IP system in general. This is opposed to how big pharma operates. Of course, they are on the highway and they ask for similar rules and regulations and in order to obtain what I referred to before as the legal certainty. So in particular, harmonized registration and effective enforcement measures, what we talked about here in the beginning through injunctions and reasonable judicial timelines and so on, they're important to stimulate the use of the IP system in general. Last one, I think also this Andrew touched upon this. There's a number of macroeconomic studies that take IP as a marker, as a surrogate marker for innovation level and innovation efficiency and capacities. And if we take a look at the Indian pharma sector in this regard, I think there's a lot of you could say positively opportunities ahead of them. So my point here is that in general, the IP system in India, also in India and in everywhere, should be to work to the benefit of innovation, and it should be remembered also for legislators that wish to have this sector to flourish. They should be careful only to use the IP regulation for solving problems that are relevant to technological advancement and innovation. Okay, my last slides, if you could bring that on. So I'll go a little more into, take a closer look into the Indian patent system. And my ability to do this relies to a great extent on the profound collaboration that our office in Denmark has with the DKPTO in India. And we are very proud and happy to collaborate with the Indian authorities, because not only because they have a high level and high standard of working, but also because the magnitude and the conditions are so different from ours that we can learn a lot from each other. I think that the Indian pharma sector in general has a potential partner in the national IP administration. However, I think there's a few areas here of special attention, and we can discuss that in the Q&A afterwards. First of all, legislation, and we have touched upon this many times for the last hour or two. The Section 3D, which is installed, as we see it, made by the fear of evergreening, or by what is sometimes referred to as incremental innovation. So it's more likely that these we call societal concerns to public health and healthcare expenses has made this topic especially relevant to pharma patents. Okay, so office conditions. Also, I think Andrew touched upon this, the volume and the geographical spread of the office, and also it was mentioned by Dr. Patil before that it's certainly a challenge for the Indian authorities, and it calls for a strong development of operational digital solutions and video web-based inter-office communication. But also, it should be considered that the office should act generally in order to minimize what we refer to as the administrative burdens and then red tape in general for businesses, if it is wanted that they should flourish and use the IP system more offensively. Ease of transparency, the ability to put up registers and make access to IP registers, IP information in general. Effective communication during prosecution, accessibility, accession of office controllers or patent examiners in need of any services that you could think of, pre-filing service and information. Also, of course, we heard from Dr. Patil today that oral hearings are welcome today, and I believe it's very, very positive to work this way. Knowledge and practices, yes, to comply with in general with the international standards is one important aspect. However, consistency is in office outputs during registration is just as important. Of course, it would be nice to have consistency and international harmonization in general, but consistency, I think, in order to obtain this legal certainty is very, very pivotal for the sector, for the pharma sector. And taking all these changes in the legal background and the legal stuff that has been changed, or legal changes over the last 15, 20 years, in mind, I think that the office, the ability in the DPIT, or the Indian Patent Office, to share what we could call an institutional mindset, a common mindset, it should certainly be considered that given the conditions for the office, it takes time to build these things in. Any changes and any common institutional mindsets takes time. The institutional knowledge and crosstalk between individual employers, we talked about that before, but it should be, and it needs to be easily accessible. Also, given the number of examiners and the spread of technologies today, they need to have access to each other in order to be able to operate the system. And my last point here is that quality management might be one factor for the office, the Indian Patent Office. I know that it is an aspiration to implement quality management in in the office. And from our side, the Danish side, we're very proud and happy to collaborate with the DPIIT on these topics. And the quality management as such will help nothing. Of course, it's the content of the system as such that would bring in all these consistent approaches and all this. You could call it certainty for the applicants in general. Okay, my last point, international harmonization. So yes, this is what we, from our point of view, from a Danish point of view, this is extremely important because we are a very small country. And I believe that India is striving to comply with all these WTO standards and a number of these legal and practical adaptations has been made. And to this end, the recent signing of I know that has recently been signed at a PPH or patent prosecution highway agreement with the Japanese authorities, and it's definitely a positive sign and shows that there's an aspiration to integrate with the international standards and practices. And this struggle will, I believe, not only help the Indian IP authorities to improve on performance and international recognition, but also will help the sector to better to comply with international standards and thereby reaching, you could say, the next level of innovation capacity and exploiting the possibilities within IP. So by these words, I would like to thank you for allowing me to share this view on the Indian pharma sector. Thank you.
Thank you, Mogens. So we can open the Q&A session now. And the first question we have from Arvind KJ. And the question is how the patent office is geared up for the patents filed in 2020, considering the pandemic. As the officials are functioning 1:3, whether it'll lead to piling up as previous years applications are also pending, or will take extra efforts to keep the applications under control. To you, Dr. Patil.
Can you once again read that?
Okay, the question is from Mr. Arvind KJ. I'm not sure where is he from.
You can click on the chat box down the bottom of the screen, and then the question will come up in the right-hand side of the screen, if that's helpful for you to read it. Dr. Patil.
Yeah. Indian Patent Office considering employing the timelines for controller to issue decisions after oral hearing. In absence of clear timelines, substantial delays are still seen in few cases. So as far as the timeline to issue the orders or decisions, I think so there is no provision into the law. What he's saying is correct. But internally, that once the hearing submissions, because after oral hearing, applicant used to submit the written submissions. So once that written submissions are submitted, within a month, it is generally a practice to issue the order. Particularly if it is a grant, it is immediately done, because grant order is not so much lengthy to justify why he is granting. But if it is a adverse, requiring to justify the decision with respect to the refusal, so certainly it takes some time to write, but it is an issue which can be taken up by the authorities if there is any provision can be made for a timeline, prescription of a timeline. I can't right now say if there is, I can only say what is the provision, but what provision government shall make, that I can't right now answer.
So, Dr. Patil, we have a chat, a question in the chat box from Dr. Arvind. How the patent office is geared up for the patents filed in 2020, considering the pandemic, as the officials are functioning 1:3, whether it will lead to piling up as previous years applications are also pending, or will it take extra efforts to keep the applications under control?
Of course, during the pandemic, the officers were allowed to work on that our system, work from home was option there. And if you see the statistics, I have a statistic that we have an average of last, if you see last to last year, 2 years, 85 and 80,000 applications. So we have some average per month. What is the average of examination and disposal in every month back to back? So our office is monitoring that, and I don't think so we are lagging behind, because all this infrastructure we have provided, or work from options are provided, and that examination rate or disposal rate is not going down. And I can't understand what is that functioning 1:3. What does it mean? Hello.
Maybe Dr. Patil, I think maybe the question is around the fact that maybe only limited number of examiners are able to work during the pandemic. But I think you answered that question by saying that people can
Not
remotely
like
work.
that, not limited. All are working. Some are, because we have made a roster duties, and according to roster, some people were attending office, some people were working from home. But it does not mean that they were on the leave or they were not working. They were working from home.
Okay, so do we have more questions? I see one more.
Yes, Kavita ma'am, we have a question in the Q&A box for Dr. Dinesh Patil. I've pasted it in the chat box, ma'am, for everybody to go through.
We have seen that timelines for hearing. That question is the same question of which
All right. No other question.
This is the same question. Yes, yes. Any other question for Honorable Justice Manmohan Singh?
I have a question, Kavita, in case time permits.
Yes, I know we are running short of time,
yes.
but definitely 2 or 3 more quick questions can be done. Yeah.
Great. I'll just quickly do it. Your Honor, I have a question. You mentioned the importance of appointing neutral experts and in patent technical matters. I wanted to understand from you, the inside views as to what challenges courts or judges face as to the appointment, first of all, and then as to the consideration of the opinion of such experts, whether parties object to it, or what challenges do you face generally, and how do you deal with them?
I can tell you there is a provision, Section 115 of the Patent Act. Scientific expert can be appointed. So one further thing is there. Normally, basically this Section 115 can be invoked by the court if necessary. If necessary. Otherwise, it has always been seen that expert opinion affidavit is already there from both sides. Plaintiff will file also expert affidavit, defendant will also file the expert affidavit. And our experience is that the person who has given the report in favor of the plaintiff will speak the same tone of the plaintiff, and similar is the position of the defendant. Now, if as I've already mentioned to you that the judges are appointed also from the different background. They are not expert. Most of the judges who have never dealt with IPR matters. Only earlier point of time in 2008, me and now Justice Pratibha M. Singh. Therefore, basically, this point was noticed earlier that the expert should also be appointed under Section 115 of the Act. Now, basically, then the question comes, who will be appointed, who may be biased in favor of one of the party, either in favor of the plaintiff or defendant. Now, this question was discussed with the other judges, retired Supreme Court judge, as well as Bombay High Court judges, as well as Delhi High Court judges, because I am already retired, but this issue was discussed to great extent. I'm telling you, they may be having some panel who are totally neutral person. Either they are expert from the industry or some technical organization, and even some of the advocate who are totally neutral, honest, and unbiased towards any party. So this will definitely help the court when the matter is taken up. Suppose the matter is pharma matter is there, and it is a technical matter, and suppose the case is given to some judge who has never dealt with this issue involved. So under section 115, he can take the expert opinion. He can also go through the expert affidavit of both the parties. But I can tell you that whatever discussion has taken place, you will be having totally neutral person in future. And I'm very much hopeful that no bias report would be there. And whatever is the correct position, it will come before the court.
That's very helpful. Yeah. Okay.
So any more questions? I don't see that on the Q&A chat box. So since there are no more questions, I would like to, thank you. I would like to thank all our distinguished speakers, INTERPAT, for their valuable contribution in this very important session today. I would also like to express my sincere gratitude to Lex Witness for the kind support in organizing this webinar. And once again, many, many thanks to all the participants who joined us for this session. It was indeed very engaging and insightful indeed. Thank you so much, everyone, and stay safe. Have a nice weekend. Bye-bye.
Thanks,
Thank you
Nam.
so much.
Thank you.
Thank you.
Thank
Thank
Bye-bye.
you. Have a nice
Thank you.
weekend.
Thank you.
Bye.
Thank you.
Bye-bye.
Thank you.
Thank you,
Bye-bye.
Dr.
Bye.
Patil.
Thank
Thank
you.
you.
Thank you to
Thank you,
everyone.
sir.
Thank you so much,
Thank you.
Thank you,
Kavita,
sir.
Thank you, Morgan.
Your-
Thank you. Thank you.
Thank you so much.
Thank you so much, Your Honor, Dr.
Thank
Patil,
you.
and all
Thank
other
you.
esteemed
Thank you.
panelists. Thank you so
Thank
much.
you.
Thank you.
Thank you. Thank you so much. Thank you, Mr. Bhola. Thank you.
Thank you so much.
Kavita, ma'am, seeking your permission to end the webinar
Yes,
now.
please. Yes, please. Thank you so much. Thank you.
Thank you.
Most welcome.